So, good afternoon to all of you. Welcome to this seminar. We have resumed face-to-face seminars recently. So I think this is one of the first face-to-face seminars organized by the Philip K. Wong Center for Chinese Law. Center for Chinese Law was recently renamed the Philip K. Wong Center for Chinese Law, and we had an inauguration ceremony a few days ago. So today we are very fortunate to have with us an old friend, but also a very distinguished scholar, giving this seminar on legal reform in contemporary China. So Professor Hugh Ngoc, as you may know, he is Professor of Asian Law at the Faculty of Law at University of Oxford, and a Fellow of St. Hugh's College, Oxford. So actually, Dr. Who did his PhD at the University of Hong Kong in this faculty. And before he came here, he was teaching at the Vietnam National University, where he graduated himself. So after completing his PhD here, he worked at the Center for Asian Legal Studies of the National University of Singapore for a few years, where he was a research fellow. And then he joined our sister law school, the Chinese University of Hong Kong, as an assistant professor. So a few years ago, he was appointed associate professor at Oxford, and now he is a full professor there. And congratulations, by the way, on your promotion. So also, and if you search the internet, you will find many articles in many leading journals published by Professor Hugh, and he has also published a few books. His latest book was published by the Oxford University Press in 2020, and it's on constitutional change in the contemporary socialist world. So if you have not seen this book, you are encouraged to have a look at the book. And previously, he has also published in 2016 an earlier work on Confucian constitutionalism in East Asia that was published by Routledge in 2016. So I understand that in his book on constitutional change in the contemporary socialist world, Professor Bill has written about the cases of China, Vietnam, and other socialist Asian jurisdictions, including North Korea and Southeast Asia, such as Vietnam. So today, he is demonstrating the broadening of his research to cover not only constitutional law, but also legal reform generally. So today he's going to talk to us about legal reform in contemporary China, which is the topic which we are extremely interested in. So without further ado, I hand over to Professor Hugh. Oh, sorry, I forgot to use the mic. Can it be heard? Yes.
Yeah. Thank you, Professor Chen, for your.
Use the mic.
Yeah, no, I can speak loudly. For your kind introduction, I should add that when I did my PhD here, Professor Chen was my supervisor, and my book on Confucian Constitutionalism was basically based on my PhD dissertation. And I thank Professor Chen for very productive supervision, and I also want to thank the Philip K. Wong Centers for Chinese Law for hosting me as a visiting fellow in this fellowship. So let me share. Okay. legal reform is a common in global legal development. Legal reform is a part of major transformation of Western legal systems, including the US and the UK legal systems. And particularly legal reform is very prominent in developing countries. After the collapse of the Soviet Union in the late 20th century, many countries in Central Europe reformed the legal systems to facilitate economic development and also state building. Five remaining socialist countries, including China, Vietnam, Laos, North Korea, and Cuba, did not just form into a democracy, but they also significantly reformed their legal system in different ways in the last 3-4 decades. So the purpose of this research is to understand how and why these countries reform their legal systems. So this talk is based on 2 chapters of my book on legal reform in the contemporary socialist world, in which I discuss legal reform in 5 current socialist countries, including China, Vietnam, Laos, North Korea, and Cuba. And this presentation is based on 2 chapters on theory and also on the case of China. So in this talk, I will present the theory, and then I will apply that theory to the case of China. So I know that you understand China's legal reform better than me, so I will focus more on general features rather than details of legal reform, about theory and general features. So basically, the theory can be summarized in 1 sentence. Legal reform is intentional change to improve an existing legal order, normally through legislation to bridge the gaps between existing law and commitment, law and society, and domestic law and just national legal norms. So I will explain these features later, but basically the theory has 3 of 6 elements. The first is intentional change. The second is incremental strategy. The third is legislative methods, positive direction, bounded scope, and gap factors. So now I will explain these 6 elements of the theory. The first element is intentional change. Legal reform is intentional change. It's different from evolution. Evolution is legal change happening naturally due to the systematic interaction beyond human intervention. Legal reform is not that kind of legal evolution. Legal reform is an expression of human beings' will, beliefs, and aspiration. And the second thing about the intentional nature of legal reform is designed change. When you design change, you have some reasons for change, the goals of change, and the means to achieve that goals. And who are the author of legal reform? They are political leaders. So in this way, the theory of legal reform I present here is similar to Alan Watson's theory about legal change. But Alan Watson is focused more on legal elite, professional lawyers. Legal reform is not just about professional lawyers. Professional lawyers can play some role in legal reform, but by the end of the day, political leaders decide and formulate projects for legal reform. So this is the difference between this intentional model with Alan Watson's model. The second element of my theory is about strategy of legal reform. So legal reform, so normally political leader will adopt incrementalism as a strategy for legal reform. So I define incrementalism as a deliberate choice of political elites to implement change to improve the existing legal order over a long time. So why political elites need incrementalism? A lot of factors, because they don't have enough knowledge about existing law, because the measures for legal reform are not specified, because the consequences of legal reform are unpredictable, because they don't know how the people will react to legal reform, and because they have different views and interests and preference about legal reform. So they have to do incrementally. But there's no single way of incrementalism. Many years ago, political scientist Charles Limbaugh developed the theory of incrementalism. According to that theory, he sees policy change is the result of small adjustments contract with rational, comprehensive method involving the formulation of overall plan for policy change. And in this way, there's no planned incrementalism. But I think political leaders, they can formulate an overall plan for legal reform, but they implement the measures for legal reform during a long time. So the first model, you reform the law without the plan, I will call this classical incrementalism. But when you formulate the plan and you implement the plan over the long time, so I will call this new classical incrementalism. And the method of legal reform is legislative. Legislative methods of legal reform are closely connected to the intentional nature of legal reform. Philosopher Warren said that legislation is intentional action. As legal reform is human beings' deliberative activity is carried out by the legislative decisions by institutional or personal actors like the parliament or even a single ruler. Why the legislative platform is a popular or common way for legal reform? The reason is this: because of the legislative activities is open. The popular base of legislature in most modern legal systems render legislative enactment as a legitimate and common method of legal reform. And direction, positive direction. Legal reform is not about every kind of legal change. Some legal change can be undermine an existing legal system, so that they are not qualified as legal reform. So legal reform is some legal change that improve an existing legal system. Within an existing legal system, the foundational of the legal system are normally general, ambiguous. So this creates the space for legal reform moving around in that fundamental commitment. So this is why you can reform the legal system surrounding some particular principles and values. So I identify two ways of legal reform. One is legal innovation. You introduce some new concepts and institutions to improve an existing legal institution, a legal order. Another way is legal renovation. You restore an abolished legal institution. You reconstruct a legal institution. You consolidate the function of legal institution, or you reactivate a dormant legal institutions. So this is called legal renovation. So now the difficult thing is about the positive direction of legal decision. How can we measure the positive direction? So I identify two standards. The first standard is the general, and the second standard is specific. The general standards of legal reform refer to the internal morality of law as theorized by philosopher Fuller, including general norms of formal rule of law, such as general, public, prospective, coherent, clear, stable, and practicable. The more difficult thing is about the specific status of legal reform. The specific status of legal reform are the commitments underlying a particular legal system and a particular legal order. different legal systems are committed to different principles and values. So the way you measure whether a legal change is a legal reform or not is to consider whether that law change can contribute to the continuing realization of the fundamental commitment. For example, if you are committed to socialism and you reform the law, that law should contribute to your fundamental commitment to socialism. But if your legal system is committed to individual freedom, when you reform the law, that law should contribute to the continuing realization of your commitment to individual freedom. So you don't have in this way, you don't have a single substantive standards to measure the possibility and the positive direction of legal reform. And the scope of legal reform, I call this the bounded change. Legal reform is limited within legal identity. By legal identity, I mean fundamental principles and values that define the nature of the legal system. Legal reform cannot escape the identity of the legal system. This is the difference between legal reform and legal revolution. Legal revolution will change the fundamental principles of values that define the nature of the legal system. For example, transformation of Confucian legal system in China into the socialist legal system. That is legal revolution, not legal reform. Legal reform is legal change within an existing legal tradition. And in legal reform, the continuity of legal identity is not natural. Political leaders, they try to do some way to deliberately entrench the fundamental commitments. And the function of the entrenchment of legal identity is two things. One is to preserve the current legal order. The second is to prevent legal evolution and legal revolution. Because if they don't do that, the development of legal change for a long time can lead to legal evolution beyond human being intervention. And maybe by the end of the day, they can lead to revolution. So this is why political elites, they try to do some way to entrench, to make sure that the identity of the legal system cannot be changed. And finally, why do countries reform their law? There are a lot of factors, but I just group all the factors into three categories, and I just call this the gap factors. One is the internal gap. Countries reform their law because there is the gap between the existing law and their commitment. When you committed to socialism, modernization, industrialization, but your law did not fit to that commitment. So you have a motivation to reform the law to make sure that your commitment can be realized. So the gap between the current law and the fundamental commitment can motivate political elites to reform the law. The second factor is the external gap, or the gap between the law and society. When the society develops and law cannot follow the development of the society and economy, political leaders will reform the law. It's not just to reflect social change, but also to facilitate the continuing development of the society and the economy. So reform the law to facilitate economic development. Social development is another factor. The final factor is what I call external gap. The gap between the law of a country and international standard. So when a country see that their law is behind the global or just national standard, they have a motivation to reform the law to meet with the external standards. So sometimes countries change the law because all the countries change the law. Countries reform the law because the international law changed. So I call this the international standards. And this is why you see a lot of legal reform come from legal plantation, legal diffusion. Like you join WTO and you need to reform the law to meet with the global national standards. So this is the basic ideas behind the theory. And now I will apply the theory to the case of China. So I will talk about intentional nature, incrementalist strategies, legislative methods, positive direction, valid scope, and the gap factors. Intentional nature. Legal reform in China is not natural change. These are designed change by the Communist Party in China. And legal reform is the expression of the intention, the will, aspiration, and belief of particular party leaders in China. And I give you some examples here. When China first opened up the economy in 1978, in the third plenum of the 11th Central Committee of the Communist Party, they decided to reform the legal system, and they focus on the idea of socialist to create a socialist legal system. And then in 2000, so after some achievement of legal development, in 1997, the party decided another project to create a socialist legal system with Chinese characteristics. And then after a few decades of legal reform under the leadership of Xi Jinping, the party decided another program, another project to create a socialist rule of law with Chinese characteristics. So legal reforms are not something that happen from the society or naturally phenomenon, but designed by political leaders, and particularly by the Communist Party in China. And I have an observation that legal exceptionalism emerged as a strong intention to construct a China's distinctive legal social system, legal model in China. So that when Deng Xiaoping initiated legal reform measure, he did not talk about distinctive features of the Chinese legal system, but since 1977, the political parties in China turned to the idea of the socialist legal system with Chinese characteristics. And then especially under the leadership of President Xi Jinping, I said that China legal exceptionalism reached its zenith. And the factor is this: economic development, some achievement in legal reform, and the China rise as a global power consolidate the Chinese Communist Party intention and confident to move into their distinctive way of legal reform rather than to copy Western or international legal model. So legal exceptionalism is the dominant and strong intention of the Communist Party, and that informed the legal reform project in China. The second element is the classical incrementalism. So the two models of incrementalism in between 1970s and 1980s, China adopted the classical model of incrementalism. It just has sporadic, small adjustment to the legal system without a comprehensive plan. But for example, Deng Xiaoping said that there's a lot of legislative work to do, and we do not have enough trained people. Therefore, legal revisions will inevitably be brought to start with, and then be gradually improved upon. It's better to have some laws than none, and better to have them sooner than later. So they don't have a comprehensive plan to reform the legal system. They do sporadically. But since 1997, China has already achieved some legal reform, and the party is more confident to design a comprehensive plan for legal reform, but they implement that legal reform during a long time. So I identify several plans for legal reform here in China. In 1997, they had the plan to create a socialist legal system by 2010. And then under Xi Jinping, they have the plan to create a socialist legal system, especially by 2020. 2025, and then basically formulated by 2035. So why do they have they turn from classical into new incrementalism? Two things. One is the achievement of legal reform make you confident that you can design a legal reform project. Another thing, the centralization of power. You cannot design an overall plan if there are diverse power. The Western countries, Western democracy, for example, they normally cannot design a comprehensive plan for legal reform because of the nature of multi-party election and multi-party system. But under a centralized legal system like China and Vietnam, the party there's some agreement within the party. Some people dominate or control the political system, and they can design a overall plan for legal reform. This explains the change from classical to new incrementalism in China. Legislative methods. Legislation is the main source of law in China. The enactment of laws by the National People's Congress and its standing committees has played a key role in legal reform. And so you see, I know that there are many kinds of legislative source of legal documents in China, including legislative level and local level, but all of the change regarding all the features, all elements, all areas like criminal law, civil law, commercial law, banking, finance, all include the enactment of law by the National Congress on its standing committee. And even the reform of the court system, the administrative system, the professional system, all involve the enactment of some laws by the central government. So this is consistent with my theory that legislative method is a dominant method of legal reform. Positive direction, so a lot of things to talk about that. After 3-4 decades, China has created a sophisticated system of general public legal rules, very comprehensive, covering nearly every aspect of the society. And according to the government, there are 293 laws divided into 7 branches: constitutional law, admin law, criminal law, civil commercial law, economic law, social law, litigation and non-litigation procedure laws. Very comprehensive. The second positive direction is about the admin law. A lot of laws about to facilitate administrative reform, including the law on litigation, state compensation, punishment, supervision, review, licensing, and civil servants. The development here is this. The enactment of law in this administrative system demonstrates an attempt to legalize the administrative system in China. To subject the administrative structure and action to law is an important depart from the administrative management by personal fears. In the substantive area, some laws, for example, the litigation law or the state compensation law, seek to impose some legal limitation on administrative power to protect individual rights. This departs from the conventional socialist understanding about the function of administrative law is just a tool, the instrument for the state to control the citizen. Judicial reform. Again, 3 laws are enacted to facilitate judicial reform, including the law on the courts, judges, and assessors. So I identified 3 trends in judicial reform in China. Structural change regarding the establishment, departmentation, specialization of the court system. Personal change, professionalism, and the functional change, the judicial capacity to resolve a vast number of legal disputes. And the important thing is that courts in China have a legal function. It's not just the political tool for the parties, but they also have the legal function to resolve legal dispute among the society. Finally, legal professional reform, again, a law and lawyers were enacted to facilitate legislative reform. The structural and personal change, the rapid development of a number of lawyers and law firms in China in the last 3-4 decades. And the functional change is the transformation of the role of Chinese law is a Soviet style of state workers into professional persons. They are more willing to challenge the government to protect the individual rights and especially in commercial cases, they are more active. So that is about the change. That these are something that are not changed in the Chinese legal system. Even though there are significant changes, the core features of the socialist law remain in China. And China legal reform cannot escape 5 core features of socialist law. And I call this incrementalism. Refer to the idea that law is an instrument of the ruling class, and particularly in China, the working class, to institutionalize the party policies, to control the society, to pursue socialism. Law is an instrument for the working class. That idea remains prominent in China now. The second is vanguardism. The vanguardism refers to the leadership of the Communist Party. The Communist Party is not a private party, a private sector to compete for election, but the Communist Party plays a vanguard role in the society and in the state. Centralism, centralization of power. There's no separation of power. Economic statism, the domination of SOEs and the state ownership. Rights-taxism. Individual rights are available in China, but individual rights are given to citizens by the state, and the state will regulate that rights practice. Individual rights are not, according to the socialist model, are not natural human rights internal to you as a human being. Individual rights are created by the state, controlled by the state, regulated by the state. So you can see the expression of these 5 core socialist features in China in many aspects of Chinese law. And I emphasize some important influence of these socialist features in different dimensions. Incrementalism and vanguardism influence nearly every aspect of Chinese law. All laws in China under this is the expression of the party leadership. When you make the law, the party must agree on that lawmaking. So lawmaking is under the party leadership. Vanguardism, centralism is very prominent in constitutional law and administrative law. Economic statism, civil law and commercial law, economic law and social law. Rights-taxism, constitutional law, administrative law, criminal law, civil, commercial law, and litigation and non-litigation law. So I don't have time to go into detail, but these are the prominent instruments of socialist law, socialist legal features in China. Factors, the same, 3 factors, internal gaps. Legal reform is driven by the need to realize the socialist commitment to modernization, industrialization, and state building. They're committed to modernization, industrialization, and state building. And that commitment, the current law is inconsistent with that commitment. So the party has the motivation to reform the law, to realize that commitment, to pursue socialism. External gap. Social change trigger legal reform in China. Social change, social economic development trigger legal reform in China. Normative gap. The influence of the diffusion of international and comparative law and international law in China through 3 mechanisms. Inducement, when you inducement, horizontal inducement, some countries from Western countries or international actors, they come to China and they try to advise China to reform the law according to international standards. Vertical inducement, when you try WTO, you need to reform the law according to the WTO standard. Learning, China's arm persuaded by the external norms and they copy that norm into the legal system. So the development of civil law in Europe, for example, triggered the development of civil law in China. Socialization, human rights provision, for example, China adopted the notion of human rights into the Constitution to be a part of the global international order, to avoid international sanctions, to avoid international criticism. So these are some mechanisms for the diffusion of external legal norms, transnational legal norms into China and trigger China legal reform. So that is the basic ideas in my 2 chapters, and I have 3 conclusions. First, despite significant reform in 4 decades, legal system in contemporary China belong to the socialist legal tradition. Chinese law is the historical extension of the legal embodiment of the Marxist-Leninist arguments about socialism. Due to the socialist boundary, the substance of legal reform in China has nearly reached to zenith. It's nearly come to the final point of legal reform. Is there no substantial room for China to reform the law in the fields? Not many space for legal reform. Is nearly what have already done in China in terms of substance. So but the future of legal reform in China will be mainly about internal morality of law. It's mainly about the formal features of law like consistency, transparency, gravity, stability, and participability of the legal system. I'm stopping. Thank you.
Okay, so because of time limitations, I think we will have to close the seminar here. So thank you very much for the enthusiastic participation of members of the audience, both here in this room and online. Thank you for your very interesting questions, which I'm sure will be stimulating for everyone here, including Professor Hugh himself. So, so thank you again for attending this seminar, and we look forward to seeing both Professor Hugh and members of the audience in the foreseeable future.